All right. Our next panel thank you, is State of the Data on ATI, Alternatives to Incarceration, Effectiveness. Let me introduce our moderator, who will then introduce our panel. Our moderator is me. I'm an attorney at Covington and Burling in New York. I've been there for 21 years. Before that, I spent a total of 12 years in various capacities at the U.S. Attorney's Office for the Eastern District of New York. So I'm a former federal prosecutor. I'm a member of the board of the Center for Justice and Human Dignity, and I also provide services in a pro bono capacity to the Olive Institute. What a nice introduction, Alan. Thank you. Now let me introduce our panel. Christine Dozier has served for 15 years as the Chief U.S. Pretrial Services Officer for the District of New Jersey. She worked with pretrial services for a total of 30 years. She served on many advisory committees in this space and is the federal representative on the board of the National Association of Pretrial Services Agencies, or NAPSA. Dr. Gipsy Escobar is the Director of Product Strategy for Measures for Justice. She has extensive multidisciplinary experience in criminal justice research and has worked with national experts to design a system to measure the performance of local criminal justice systems and to standardize the management of criminal justice data across jurisdictions in the United States. Talk about pushing big rocks up a steep hill. And then finally, Vikrant Reddy is a senior fellow at Stand Together Trust. An attorney, he has managed the launch of the Right on Crime initiative at the Texas Public Policy Foundation and has served on the boards of the Wilson Center for Science and Justice at Duke Law School and on the executive committee of the Criminal Law Practice Group at the Federalist Society. So, we've heard quite a bit already about alternatives to incarceration, and it sounds great. Here's my questions, which I can hope we can address during this panel. Is there data to show that this approach actually works? If so, what does that data show? Is the data reliable? Is there enough of it? Are there challenges in collecting and comparing that data? How do we get more usable data to inform the discussion? And what do we mean by it works? What metrics do we have in mind in order to measure success? And how do we best go about measuring it? With that, let's hear from our three panelists. They're going to each speak to you for a few minutes to start, with discussion and audience questions to follow. You're all terrific, so I'm going to do this in alphabetical order, starting with Chris, then Gipsy, then Vikrant. So, Chris, take it away.
How's that?
Yep.
Okay, so good. We're still in morning, right? In many ways, but that's another story. Going back to about around 2015, there was a lot percolating with all three branches of government expressing support for alternatives to incarceration and diversionary programs. The Department of Justice had their Smart on Crime initiative to prioritize the most serious crimes for prosecution and use ATI for low-risk, nonviolent crimes. And the reentry movement, putting points of contact in every federal district to work with their state and local counterparts. It was just a huge supportive initiative for the back end. And those of us on the front end, the pretrial people, were saying, seeing these people coming out of prison after 5 years with no GED, no therapy, nothing, if providing these supportive services is good for them now, why wasn't it good for them earlier when I had them under supervision for 2 years, or when unfortunately, he may have been detained for an average of a year and plus. So that was, the executive branch was doing things. We saw the First Step Act passed. Congress, on its part, had the Colson Task Force. They issued a report saying federal prisons should be reserved for the most serious, and ATI should be encouraged and incentivized. And the federal judiciary showed support for it by testifying before the Colson Task Force about the underutilization of traditional diversion, which is pretty much non-existent in the federal system. And, we tend to forget that traditional diversion is a very simple means by which we can reduce incarceration, but we're just really not using it at all. And the federal judiciary committed to work with the Department of Justice on that. The U.S. courts, our probation and pretrial strategic plan in 2017 was to identify alternatives to incarceration that address the purposes of sentencing for low-risk, nonviolent cases, encourage more traditional diversion, and promote evaluation of ATI courts. And so we heard from everybody about the will to do it, but as we know, the devil is in the details. And so, despite all this goodwill and commitment, those of us in the field just didn't feel like the progress was moving at the pace that we would like to see it move. So what happened was all these ATI courts started emerging. There was a proliferation of these front-end pretrial specialty courts, and the Sentencing Commission did a review, so to speak, in I think it was 2016, and what they said was if there's just no data to support this right now. So it's on that backdrop that a number of us chiefs in the field decided that we wanted to do our part to try and provide that data and support. So in 2018, I reached out to Kevin Wolf, a professor at John Jay, criminal justice professor, criminologist, a researcher who's been wonderful, by the way. And I contracted with him, and I reached out to a then recently retired analyst from the Office of Probation and Pretrial at the federal courts, who was an amazing, best grab I ever took, Laura Baber, and hired her as a research coordinator for the work that we wanted to do. And at that time, we got 7 federal districts to jump on board for this first phase of studying our ATI courts. So you threw a lot of questions out there, the challenges, the methodology, the outcomes. Shall I just continue with all that? Or?
Yeah, I set a high bar, so let's clear it.
Okay, so there were a lot of challenges, but we tackled them. It took some work. There was no methodology. There was no way to identify these programs and participants in our system. There was no standardized way to extract that data from there. We had to go in and do a lot of data entry and cleanup. We had students and support staff do it. We helped do it for other districts that didn't have the means to do it. And our administrative office, John Fitzgerald's the chief here, they helped us in any way they could in support of this research that we were doing in terms of helping get that data pull. We developed those data points. We looked at the known correlates to criminal behavior that we captured in our system. We actually have a pretty sophisticated and extensive, with hundreds of data points in our system. And we studied it in the aggregate. Some of these programs just didn't have enough data to have their own individual studies. So these 7 districts were done in the aggregate. And the end result is the findings were extremely positive. We had 87% graduation rate, and if you look at any DCP, it indicates about a 50 to 75% in state and local systems. We had successful outcomes on pretrial, less rearrest on pretrial for people who participated in these programs, less drug use, more employment. But what was really amazing was the case dispositions. We had, for those who successfully completed ATI programs, we had a 50% diversion dismissal rate compared to 0 for their matched counterparts. We used propensity score matching, so we matched people on a whole host of characteristics. So we were capturing apples to apples, comparing apples to apples, and there was 0 in our comparison group. Of those who did get sentenced, there was significantly less jail. Those who received a jail sentence who were participants, it was an average of 3 months compared to 33 months for those who did not, on average, matched participants. And also, we couldn't tell what was a time-served sentence. So we couldn't differentiate that data. So the rates of incarceration upon sentencing would have been even lower for our ATI participants because some of it represented ATI. Based on the positive findings of that study, we set out to try and take it to the next phase, which we got additional districts wanted to join in the study. So then we had 13 districts. So the first thing we did was replicate the findings. And the result was the same very positive outcomes, the same very positive dispositions. So we demonstrated that ATI was clearly indicative of success, of improved outcomes, and without having to have the obvious high costs of incarceration and the collateral consequences that comes with that.
Great, thank you. Gipsy, talk about the data. Is data gathering as easy and is it as terrific as we just heard it described, or is it more complicated than that? And if so, how so?
It's a lot more complicated than that. So I work for an organization called Measures for Justice. For the last 12 years, we have been collecting court and prosecutor data, and we're starting to collect now police data as well, to develop basically data tools for criminal justice agencies, looking at public transparency. So we work with a number of, we work with 20 states for our national data portal. As I was preparing for this conference, I was looking at pretrial diversion data in those 20 states, and we only have it for 1 state. So that's telling right there. We're now working with prosecutor offices, and our dashboard that we're working with them follows kind of like the case flow, right? Like it just basically tracks decisions that are made at different parts of the process by the prosecutor offices. And of course, that includes diversion. Both from the courts and the prosecutor data, there is multiple challenges. But Alan, do we have enough time to show a few slides with data?
You do.
Do we have the slides loaded?
We do.
I'm going to show you a little bit of, quickly, some trends in the data around diversion rates, diversion success rates, and also something that has not been very explored, which is the diversion offer result. There is tons of information on that diversion offer result that we need to explore more. So I'll start by talking. So what I've seen in particularly prosecutorial-led diversion, there has been a decline in the past 5 years. In some jurisdictions, which I actually don't have in my slides here, but in some jurisdictions there was an increase of diversions in 2020 and 2021 as a way to deal with the huge backlog, particularly of misdemeanors that was being caused by the pandemic. However, when you look at the data, kind of like as a whole across multiple jurisdictions, what it looks like is that the pandemic actually hurt diversions. During that period of time, a lot of programs had to at least temporarily close. Resources were, were lost during the pandemic. So you'll see in some of the slides the diversion rate actually has been going down across several jurisdictions. In addition to that, if when we look at the success rate, it kind of varies by jurisdiction, but it does kind of like hover over the 40 to 60% and sometimes higher rate. So it does seem to lead to success. So that's like important news. I'll talk a little bit more about measurement challenges, because what success means is something different across jurisdictions. And the other data point that I was going to show here, good? We're good? Was around the offer result. So, and this is a part that is very hidden to the public in terms of understanding pretrial diversion. Oh, we're good. Okay, so these few first slides are showing you that downward trend for multiple jurisdictions in the United States. We can move to the next one. There we go. Those are all like showing like a decline across the use of diversion. You can move next.
Stay on that one. What's replacing that? Is that dismissals that are going up?
Oh, that's an excellent point, because what is observed in a lot of these dashboards as well is when they are presenting the proportion of the different dispositions, it does look like diversions are going down while dismissals are going up. There's a graph before this, if we can go back for a second, for Philadelphia.
Maybe it's forward.
Oh.
Go forward. Keep going.
Oh, Milwaukee.
Keep going.
I don't know, we lost Philadelphia.
Oh.
But at any rate, that one shows very clearly how the proportion of diversions has been shrinking dramatically in the last 5 years, while dismissals has been going up. So there is an interesting data point there as well. On the offer result, there is like loads of information there that we are not, one, capturing, and two, taking advantage of. The public tends to think that pretrial diversion is a decision that is made by the prosecutor or the judge that the defendant has to take. But the diversion decision is voluntary. Nobody is mandated to get diversion as opposed to going through traditional prosecution. And defendants do decline that offer with some frequency, and that declination, the declination of the diversion offer is important because that data could help us understand what are the challenges to access to pretrial diversion. We know that, for instance, when programs have a fee for participation, that becomes a problem for entry. We know that transportation can be a factor there. But we also know, to some extent, anecdotally, from talking to prosecutors, that some defendants just prefer to go to jail because oftentimes they think that it's going to be shorter than the amount of time they will have to be in a pretrial diversion program. And somebody was saying earlier, there is a big distrust in the system. So when there's something that is unknown, there is even more distrust there. So I do think that there is important information that we're not capturing there. So let me talk about the challenges as we've seen them in the past 12 years. So the first challenge is that there's no agreement on how diversion is defined. In a panel earlier, we heard about drug court standards, which is great that drug court standards exist, but I think those are the only standards that exist around pretrial diversion. We heard about veteran courts. We heard about law enforcement assisted diversions. We heard about electronic monitoring. The reality is that if all of these things are being considered as diversion, we're lumping apples and oranges together, right? Like all of these interventions mean something different and have different expectations of behavior, and they have potentially different outcomes and unintended consequences, like we were talking about earlier with the electronic monitoring. So in terms of measurement, we need to come up with kind of like a uniform way of defining diversion. And this doesn't mean that all diversions have to be the same. What it means is that we need to be able to capture that variability on what the programs offer in a kind of like a reliable way, so that we can look at differences across programs. Programming varies widely by jurisdiction. Some places will have a drug court, another place will have a domestic violence court, another place will have a juvenile court, but they're not really, necessarily the same menu of offerings across jurisdictions. Each jurisdiction is going to have a different menu. There is also a problem with fidelity in implementation that is rarely measured in research methods. Fidelity means that you are implementing the program as it was designed, and that if you deviate from that design, then it's going to be hard to really measure the impact of that program as intended, and we are rarely kind of like measuring that fidelity in implementation. Diversion data is extremely decentralized. When we came out 10 years ago, we went out collecting core data, and we started with data with states where we knew the administrative office of the courts centralized all core data for that state, because if otherwise we'll have to do data collection in 3,500 different courts, which is not efficient. So in addition to that, the diversion data tends to not be kept with other case data, so it tends to be kept sometimes outside of prosecutor offices or courts. It tends to be kept sometimes individually by each diversion program, and not not bringing all the diversion programs together in the same jurisdiction. It's often kept in spreadsheets that is not even like integrated in case management systems that prosecutor and court clerks might use. Even worse, some jurisdictions don't even know what diversion programs they have, right? So like if we don't even know what we have, it's going to be even harder to get that data to measure effectiveness. We worked with the courts in Monroe County in New York to do such inventory because they have both court and prosecutor-led diversion programs there, but they didn't know, the prosecutors didn't know what were all the options they had. The judges didn't know what were all the options they had. So it took a nonprofit to come in and do the inventory for them to see what is it that they have available. So we got to start by figuring out what is it that we have available in each jurisdiction, so that we can measure it accurately. Terrible data integrity. Oftentimes the decision to divert is overwritten with the outcome. So if you imagine a data table, right, and you imagine this cell is capturing the decision, this person has entered pretrial diversion. 10 months later, that same cell with that decision is replaced with the outcome. So that outcome is going to be, a guilty plea or a dismissal, which makes us lose completely information about the initial decision, which makes it harder and more unreliable to measure the diversion rate to begin with. So that's overriding is a common challenge and is incredibly problematic. The diversion of a result, like I mentioned earlier, is rarely tracked. And like I said before, there is a wealth of information in there. The diversion outcome is tracked inconsistently, and like I say, success is defined differently depending on the program, depending on the jurisdiction, depending kind of like on the political agenda behind the leaders at the moment. And then we had another challenge in terms of the data that are available publicly, like these dashboards that I've mentioned, is that a lot of these dashboards are measuring counts, meaning numbers, right? The number of diversions, the number of dismissals, etc. However, when we look at numbers, that it's hard to compare, right? It's hard to compare one year to the next. It's hard to compare one jurisdiction to the other because the volume of cases varies every year. So like knowing that there were 100 diversions in a given year and 55 the next year, it's not enough for me to know whether the diversion rate is actually going up or down because I have to look at the denominator of all the cases that are coming in as well. So there is also that, that kind of like challenge in terms of interpreting the data by looking at counts versus rates. Ideally, we use rates, percentages that we can actually use to compare. So you see some opportunities, if I may? Or am I too long already?
I'm a big fan of identifying the problems, but then also coming up with solutions, so yes.
Okay, thank you. So this is a tough one, but at least from a methodological perspective, it will be important to have kind of like a uniform definition of diversion on what we mean by it, so that we can actually compare and benchmark. Right now, we don't know whether a diversion rate of 5% is good enough or it has to be 15%, right? We don't know those things because it's hard to benchmark the criminal justice outcomes. But if we if we had uniform definitions and we're able to compare to similarly situated jurisdictions, we will have an ability to tell how we're doing. We need to start collecting the data on the diversion offer outcome, right? Why are people, who is accepting the offer, who's declining it, what are their characteristics, what are the types of offenses that they're being accused of, what are kind of like the social aspects that might impact that decision or not. And again, what are the barriers to entry that the system has built in? As part of all of this, we need to investigate more the diversion rate, both the positive impact in terms of effectiveness, and this is very, very much around the success definition, but also the net widening effect. Are we, the Philadelphia example, I think is online. If you go to the website for the summit, the slides will be there. The Philadelphia example was interesting because did they see that perhaps diversions were having a net widening effect, and that's what they're kind of like relying less on diversions and relying more on dismissal, so that way, like if the case were to be dismissed or considered for dismissal, why not do it there on the spot?
So it's clear to everybody, may not be. What do you mean by net widening?
Thank you. So that will be getting people in pretrial diversion who have otherwise gotten their case either declined or dismissed at the get-go. So that means that people who have been out of the system, they will have exited the system without the diversion. Now they're stuck with the system for a period of time because of the diversion opportunity.
Got it. So Vikrant, you can take on problems, you can take on solutions, and how do we get from the first to the second? Nope.
Now it's on?
Yes,
okay,
it is.
there we go. So you threw a lot of questions at us, and I was trying to figure out how to synthesize
I know you're all up
of
for
it.
it.
Well, here's what I'll do. I'll try and identify 3 alternatives to incarceration that have got serious evidence behind them. I'll talk a little bit about that. And then I'll talk about challenges behind understanding and implementing even further these promising solutions. Let's just go one by one. The first one, the most obvious one, is cognitive behavioral therapy. So I work for the Stand Together Trust, which is a grant-making institution, and we provided a grant to a great organization called the Council on Criminal Justice to really do the very thing we're talking about today. Take a look at the evidence and see what works in terms of reducing recidivism and dropping crime rates. And they found a lot of things that are promising. They found some things that didn't work quite as well. But the one thing on which they had absolute total agreement, their task force they put together, was cognitive behavioral therapy. They studied, I think, 58 different cognitive behavioral therapy using diversion programs, and all of these together produced a recidivism drop of 25%. There were a few programs that produced a drop of 50%. Really, the results were just extraordinary. The one thing that everybody in this field seems to have a lot of confidence in is the cognitive behavioral therapy. Now, like I said, let me talk a little bit about some of the challenges here. One challenge, and Gipsy, you're really good on this, is the definition issue. What does that really mean, cognitive behavioral therapy? I'm not sure that we have the tightest sense of what that is, and there's a lot of people doing a lot of different kinds of things. And, we have some broad sense that it means getting people to confront their emotions and ask themselves questions about the situation that they're in, the situation they're trying to get to, and really do this kind of internal analysis that perhaps they just never grew up doing. And, giving people the tools to learn how to do those kinds of things and handle their emotions a little bit better, that seems to work. But there's so many different kinds of programs out there, and it is hard to get a handle on systematizing all of it. It's also really difficult, even if you assume that this stuff works quite well, to scale it up, because that's a very sophisticated skill set, learning how to do cognitive behavioral therapy. Those people don't just grow on trees. You've got to train them. You've got to teach them. You've got to teach these skills in, difficult, like a university setting. That kind of thing costs money. And so there are a lot of challenges. You can't simply say, well, CBT works, let's all just go do CBT. It's a little bit more difficult than that. But that is, I think, the area where people have got the most hope. A second area that I'll talk about, and challenge I'll talk about, is diversion programs that involve employment training and employment skills. This is even kind of setting aside the analysis. There's kind of the old wisdom, right, that idle hands are the devil's workshop. People have always heard that quote. And essentially the idea you're getting at here is if you keep busy, if you're doing something, if you're being productive, if you got a job, you're probably going to stay out of trouble. It does matter. So it matters a lot to give people employment skills. But what does that mean? Whenever you say, well, give people employment skills, people think a lot about, how do we get people the technical training? How do we get people to learn how to use lathe machines? How do we get people to learn to code? How do we do that? But that doesn't actually seem to be the thing that makes the big difference. The thing that makes the big difference is teaching folks soft skills, right? Teaching people about the importance of showing up on time, teaching people the importance of eye contact, teaching people, well, here's an anecdote. I grew up in Texas, and an old acquaintance of mine used to run the biggest lobby organization for business groups in the state of Texas. And I was talking to him once, and I said, so what is the training that is needed out there? What kinds of programs can we put these folks into just because the businesses in Texas are really desperate for this? Like, what is the job? What is the skill set? And he just kind of got exasperated with me and said, I'll tell you what I would really love to teach people. Teach people not to answer their cell phone in the middle of the job interview. That struck me as completely bizarre. I would never answer my cell phone in the middle of the job interview, and most of the people in this room wouldn't either. And nobody ever taught me not to do it, but somehow I internalized it at some point in growing up. But these folks just didn't grow up that way. And they do have to be taught these kinds of things, and those skills do have to be communicated. And so finding a way to do this is really, really important. Now, another real problem you have behind the evidence that shows the recidivism drops after people get employment training is that you can get kind of a selection bias, right? You can't really force people to go and take this skills training or job training program. A lot of times, people are incentivized to do them because you say you can earn X amount of time off of your sentence if you go and do this program. And the kind of person who responds to that incentive really well and is already motivated to go into a program and do something because they want to get time off their sentence is already a certain kind of person who's probably going to be more successful on the outside. So this is, one of these problems that statisticians deal with all the time, but it's a real selection bias problem in that area. The final one that I want to talk about is monitoring. That can mean drug and alcohol monitoring. It can just mean basic electronic monitoring. Gipsy, you've already talked about some of the problems there. But there is some emerging evidence that when you try these programs, people are being watched. They know to stay out of trouble. They don't have to literally be inside of a cage, inside of a box. We can use these tools that we have to monitor people and try and make sure that staying away from crime. Now, the challenge here, I think, is maybe the hardest of all of the three I've mentioned, because I feel like the challenge is cultural. One of the best studies I've read on electronic monitoring came out of France. And I remember as I was reading it thinking, well, how come I can't find one of this level of sophistication in the United States? I think sometimes it's hard to implement and develop the programs in the United States because people have a bit of a skepticism of them. I read this really interesting paper a few years ago by a law professor at the University of Pennsylvania who's like the godfather of criminal law in the United States, named Paul Robinson. And he presented this idea that one of the values of incarceration, there are a lot of problems that come from incarceration, but one of the few good things that comes from it is that people need to have trust and confidence in their government and their criminal justice system. If they see people going to prison, then they feel like, well, I have confidence that this system is actually doing something. If, on the other hand, they see people walking around with an ankle monitor, they kind of go, wait a second, what happened to this guy? He's just going and living his life. He can do what he wants. He's with his family. He goes to work. He can, whatever, go to his favorite restaurant. He can do all these kinds of things. That's not punishment. Flipping that switch inside of Americans is a very, very deep cultural challenge to get them to understand that, no, it is punishment. And believe me, you would not want to walk around all day with an ankle monitor. The embarrassment of it, the stigma, the inconvenience, all of those things do matter, and it is a punishment. You don't have to be in a cage for it to be punishment. But that is a difficult cultural challenge. It's a cultural challenge that we face in our country in a way that perhaps the Europeans don't face at quite the same level. Although, make no mistake, they face it too. I do think there's something very deeply human about that impulse. So you do have these challenges behind finding really good data on these kinds of monitoring programs in the United States, although they are out there, and the emerging evidence behind things like ankle monitors or things like breath monitors, right? Like putting breathalyzers on people's cars and these kinds of things, or having them phone in. There are these really interesting machines where they can detect your alcohol levels through the phone that are being developed. These kinds of things are really very, very promising and definitely deserve a lot more experimentation.
I feel like I'm on a verbal roller coaster. Here's great news, but here's the challenge. Here's the great news, but okay. So let's stay on that roller coaster. Hang on tight, Chris. You talked about this study of 13 federal districts, which, as far as I know, is the largest, kind of most comprehensive study that's been done of federal diversion programs, period, right? So shout out to you and your colleagues. That was in 2021?
Yeah, that 19 was the first one in 2021, yes.
So is there more coming? Do we need more? And if so, what more is coming down the pike?
Yes, we need more. So for our part, with our 13 districts, we've continued to do some work, which we will be publishing no later than next summer because the contract with Kevin Wolf runs out at that time. So we want to wrap it up, and we'd love to see the work continue. And I could talk about what my hopes are that for the Sentencing Commission and others to run with. But the work we've continued to do now is with these the same data pool, which was about 27,000 cases that we had at our disposal. We wanted to look at a few different things. The first was the equity issue, whether there was disparity in this participation in these programs. And we looked at it based on race, gender, age, and risk level. And we found that disparity did exist, no big surprise, in program participation. Now, who participates in these programs is largely a function of the Department of Justice policies. So, we're kind of, as you heard earlier, we're at the mercy of the U.S. Attorney's Office when it comes to who they're going to admit to these programs. They have to be on board with it or they're not getting in. So there's no standardized vetting process for these programs. That's part of what we really need more of the study and the research to build into the policy making for these kind of programs. But what we found was that whites and Hispanics participated at a higher level than their representation in the general population. 46 versus 30% for whites and 30% versus 26 for Hispanics, but blacks participated at a lower level. Now, individual programs may have had something different to show. I believe there was at least one program that had higher black representation based on the population they were targeting. With the Hispanics, I know at least one program was targeting drug mules. That was a big problem in their jurisdiction. So these things are a function of the types of crimes that they're really trying to address based on the population we work with, right, which is somewhat different in individual districts. Female population was higher in ATIs versus the general population. Younger defendants was more prevalent than the general population, and higher risk cases, which is good. That says that we're operating these pursuant to the risk principle. You get the most bang for your buck, as we know, working with those higher risk cases. The good news was there was no statistically significant difference in success rates based on race or gender. Everybody succeeded at an exceptionally high rate, 87% in the first group, but it was about the same in the entire group. Where we saw more of the problems was with the younger population in our ATIs, which is no surprise, and the higher risk cases. So younger, higher risk cases were the most challenging, no surprise there. So then we decided what we really needed and what we really heard the call for was the recidivism data. So not a lot of these cases have been out of our system for a very long time. So that was one of the challenges. But we still had about 400 cases we were working with in looking at the recidivism analysis for 1, 2, and 3 years out of the system. So the first year we saw statistically significant fewer violations for ATI participants in recidivism in all major, minor violent crime areas. But that effect diminished over time. In the second year, we didn't have any statistical significance. The third year was only evidence with minor level offenses, not major. The outcomes were similar, but not worse. They were at minimum slightly better. But that was without the costs associated with incarceration. So, you know, avoiding the prison costs, avoiding all the collateral damage that we could go into for not only our defendants, but their family members, their children, and generations beyond. So, I mean, I think this is, you know, these are extremely positive outcomes that speak to the need to take a deeper dive into the role that these ATI courts can play in reducing incarceration in the federal system. We just got a new data poll, so 3 more years of data. So that would bring us through 2022. So, you know, the most recent years are going to reflect best practices. So, you know, we really want to see what's replicated, what the outcomes of that will be. We're also doing surveys, some random surveys with our participants to get that qualitative piece, which is so important. You know, just looking at the data and recidivism alone doesn't tell the really important story of whether we're changing lives. And so the quality of life, the family relationships, the employment, the stability, the housing, sobriety, health benefits, income, things like that. That's so important that we make major changes in their lives. So that's what we're doing, and we hope to publish on, not hope to, will publish on by this summer. That I hope that, you know, the Sentencing Commission will run with.
Okay, so we have a few minutes before audience questions. Let me go back to Gipsy. You identified a number of challenges with the sort of the data collection, its integrity, its comparability, its consistency. What are what are the specific practical steps that you see that can be done to solve that so that the data, at least on the federal level, if not the state level, can be more reliable and tell us more that's concrete about alternative to incarceration programs and their effectiveness?
Sure. I mean, I think the first thing would be to start collecting it. I mean, there is like, and start collecting it in the same case management system as you collect other cases. So basically, you know, work with the developer, the vendor of the case management system software to add fields that pertain to pretrial diversion, including, I can give you the list that I think should be collected. When was the pretrial diversion offer made? What was the outcome of the offer, whether it was accepted or declined, and the date for that as well. The type of program specifically, you know, there might be multiple categories, so, but at least some general categories could involve drug court, mental health court, veterans court, domestic violence court, restorative justice programs. Then the tracking the outcomes, obviously, and the time to those, you know, to success or failure. And then this has been challenging. The recidivism part has been challenging in terms of tracking it with prosecutor or court data, because it will require kind of like following the individuals for a period of time. But if prosecutors and courts started kind of like having a feel that at least indicated a flag of, you know, a new arrest and when that arrest took place, will be important. I think eligibility is extremely difficult to control for when measuring this stuff because it varies. And a lot of jurisdictions leave a lot to the discretion of, for instance, the prosecutor. But I do think in terms of like practice, based on what the data is showing, jurisdictions can be creative to open up eligibility a little more. One of the jurisdictions we work with after we published the dashboard, and they saw that they had a disproportionality of people of color, you know, basically being referred to their office by law enforcement compared to white people. They decided to use diversion as a way to mitigate that disproportionality. And what they did was to basically, they used to have an automatic disqualifier if the defendant had a criminal history. So a prosecutor wouldn't even look at the case and consider it for diversion. Now they have removed that disqualifier, and now the prosecutor can actually review the case and, you know, see whether the person will meet the other kind of conditions for diversion. So I think there is like looking at the data, prosecutors and courts can take action to one, allow more defendants to have access to diversion, and by tracking every single step of the process, they will also have the information to look at what are the barriers to access, net widening, success, and recidivism rate.
So all that sounds like you need, if I could say it, three things. You need commitment to do it, coordination, and money. So Vikrant, is there a path forward that gets us to that special place?
Yes, my email address is...
You're going to be flooded with funding
joke,
applications
yeah.
in the next 48 hours. Okay.
Yeah. Well, you know, philanthropy is very interested in this, and Stand Together is very interested in this. And yeah, there is a path forward. I mean, I was joking, but I'm not joking. I mean, if you have an interesting idea, I'm in this program, find me. Stand Together Trust is always looking to fund really interesting projects. They're investigating what actually works in the criminal justice system. And I think there are probably a lot of other funders here, and I suspect they would all deliver the exact same message. The reason that they got into this work is because they're trying to find really thoughtful ways to give the money away. So if you've got an idea, contact us.
Questions? Sir.
Possibility, given everything you're saying, that we're maybe not being bold enough, going back to the keynote earlier about the notion of addressing trauma and thinking about more, maybe that we could go bolder. And I'm saying this because there is fairly good research. I immediately come to the idea of Starr and Prescott, that people over 50 who've served over 5 years have a recidivism rate below 1%. We've seen COVID releases have very much lower recidivism than general releases. We've seen CARES Act releases, as the director just said a second ago, have very much lower recidivism than general releases. We've seen there's many examples I could give you of areas where we've done releases both for people with low risk and people who are aged, that when we're talking about aged populations, we're talking about the highest cost prisoners. We always look at it as an aggregate, but it's not an aggregate. Every day someone stays in prison, they cost the system more because of health care, et cetera, et cetera, et cetera. Are we being bold enough at the way that we're looking at these things?
Who wants to take that?
I actually have a thought on this because I thought about saying something like that, but wondered if it would be off topic. In some cases, this is called alternatives to incarceration. Maybe the best alternative to incarceration is nothing. Not in all cases, but in some cases, it's just nothing. It's not, oh, is it this program? Is it that program? Is it this kind of diversion? It could simply be nothing at all. So you've mentioned a number of really good examples. Another way you could think about this is imagine there's a possible sentence for some crime of 4 years, and you reduced it to just 2 years. You could ask, well, what are we going to do instead of those other 2 years they were behind bars? And the answer could be nothing. And there is plenty of evidence to support the idea that perhaps a lot of the sentences in the country are just far too long. In fact, I mentioned the Council on Criminal Justice earlier. One of our grantees, they produced another task force that looked at extremely long sentences and looked at whether or not those were actually producing the recidivism declines that we were looking for. Not necessarily. And so a lot of these sentences that we have in the United States could be reduced. There's another area where you want to go even bolder, not just reducing sentences. There are entire things that could simply be decriminalized. And the easiest and most obvious is perhaps cannabis. Cannabis sale and use and those kinds of things. Another one of our grantees is actually in the room. We'll be speaking, Doug Berman from the Ohio State's Drug Enforcement Policy Center. They do a lot of research on this question, and there's quite a bit of evidence out there to suggest that with a lot of drug crimes, they maybe don't necessarily need to be criminalized in the first place. So I think looking for categories like that where we could just decriminalize altogether would be very useful.
More questions?
Yes, I'm Jackie Dunn with Data for Change, and I focus on Florida, probably one of the most broken states in the nation of criminal justice. And I would like to talk to you about funding. That'd be great. Just teasing. But anyway, so I struggle. I have so many different questions I could bring up, but obviously,
pick the best one.
Data can change minds, even in the most conservative people. And do you see risk assessments, and that was one of the things that came out of the long sentence, one of the 15 suggestions on the long sentence, risk assessments being used more prevalently to either identify, like in Florida, we probably have 15,000 people that could be released right now because we're not afraid of them, we're just mad at them. And 30% of our 85,000 are over the age of 50, which is considered elderly in the prison system because the medical care is so pathetic. So would you see risk assessments getting used more and more prevalently to help to define the narrative on public safety, and that we're not looking to, harm the community, but actually make it better because we're not decriminalizing people by keeping them in there too long? So just wondered, because I know there's some people that don't want to use risk assessments for civil liberties type of reasons, but I think that it's going to become more and more important to not only use them, but to go back and look and see how were they spot on? Were we seeing people, that came out because we identified them as low risk, were truly low risk, or if they weren't, how do we circle that back around to hone in our assessments a little bit more even as to those that we maybe had a miss on?
Gipsy.
I would say it depends on the risk assessment tool. I think it's important to examine what risk assessment tools we are using. There are validated tools out there that have like good research, good support, that they are not adding more bias to the decision, and they are focusing really on the criminogenic aspects of the risk as opposed to race or other things like that. So I think it's important to look at the type of risk assessment. A lot of these risk assessment companies have like black boxes, and it's hard to tell what is it really that is behind the algorithm. I see Jeremy Travis over there. So the Arnold Foundation did create a risk assessment, pretrial risk assessment that is used widely across the country, that has been validated and that focuses on those criminogenic issues. So I will say that yes, there is a place for risk assessments. It would be great if we use them not only as risk but also needs assessment. But that we have to be very careful with what tool we choose to do the job.
Another question? Right there.
Yeah. Hi, my name is Dan Hafetz. I'm here with the New Jersey Attorney General's office, my colleague, Derek Daly. Christine, this is not just directed at you, although it would be great to get your response. Very curious how some of the lessons from the study that you have worked on and some of the work that's happening at the federal level, how you see state offices and county prosecutors, not just in New Jersey, but anywhere, how you see some of these lessons being learned, taken, and adapted, and how prosecutors can be worked with from your standpoint to broaden the adoption of ATI. Thank you.
Yes, thank you. Yeah, one of the things I think we really need to think about is that these programs only impact a small number of our population. So how do we take lessons learned and apply it to the wider audience? I certainly spend time thinking about that. Judge Salas, who I started a drug court with in the Federal District of New Jersey, is going to be on a panel tomorrow, and I'm sure she's going to talk about how she takes the lessons learned in ATI and applies it to all her cases in general. And I really would like to see our stakeholders do the same thing. One of the things, the New Jersey bail reform, to its credit, it's been an amazing reform effort, reducing the jail population significantly without increasing incarceration rates and rearrest rates, and they keep examining it to improve it, and recently issued a report that's on their website, and in it you talked about wanting to see the reentry model, and this is something I've been saying for years. Like, I saw the Department of Justice, it was just the hugest effort of support for people coming out of prison. Who doesn't embrace that, right? But apply it to the front end. Point of contact in every federal district to work with state and local. We have a federal detention crisis, and you can't talk about reducing mass incarceration without talking about reducing mass pretrial detention, because it has a significant impact. Thank you. There's a lot of research on this, and if you go on the U.S. Court's website and you see the Federal Probation Journal, there's tons of great research in there. Dr. Chris Lowenkamp, who we're lucky to have at the U.S. Courts, did research on the impact of the release detention decision on sentencing and beyond, and we get more jail sentences, longer jail sentences. There's work on his part that pretrial success is predictive of post-conviction success. These are things that judges should be thinking about at sentencing. If they do well on pretrial, which the vast majority do, they'll do well post-conviction. I've provided a couple studies. There's another study that came out of New Jersey, the deputy chief and the chief of pretrial, on the sentencing, the pretrial detention impact on sentencing variances. Detained defendants get 49% less downward variances, and for those who do get one, it's 26% smaller. So that in-out decision is critical in terms of reducing incarceration. And I think, your New Jersey reform is a perfect example, and I know a lot of the states across the country have been looking to New Jersey's bail reform as a model. They've spoken at NAPSA on several occasions of a collaborative effort. All branches of government, all stakeholders were all brought to the table to create a committee, a task force, and look at what they needed to do. And it wasn't just pretrial, but several other intercepts in the criminal justice system.
Let's hear it for New Jersey.
Yeah.
So here's a final note I'll leave you with. Never underestimate the importance of mingling. I was mingling this morning and picked up this piece of data on ATI effectiveness. I like it. I don't know if it passes the scrutiny of people with PhDs, but, and I picked it up from Judge Frank Montalvo, a senior U.S. District Judge for the Western District of Texas, who's with us here, and he was telling me about two programs that they have in his district that he oversees. One is a pretrial program, Adelante, for first-time low-level offenders. They've had 40 graduates of the program and a recidivism rate of 0. The second one is a reentry program that he oversees called Sendero. And that has been in operation for several years. My understanding, it has an even greater number of graduates, and its recidivism rate is 0. So with that, we're going to take our lunch break, and we'll be back here resuming with the afternoon's program at 1:50. So eat quickly.